Honorable Chief Justice and Associate Justices of the Supreme Court of North Carolina. Yes, oh yes, oh yes. The Supreme Court of North Carolina is now sitting for the dispatch of business. God save the state and this honorable court.
Good morning. Our first case this morning is Byrd et al. Versus Avco Corporation et al. And we will hear from the appellant.
Mr. Chief Justice, and may it please the court, Troy Shelton on behalf of the defendants. With me at council table today is Nicole Benjamin. We also have with us today in the galley the general counsels of the Home Builders Association, Liz Stevens, and of Gamma, Karsten Hoyt. I'd like to reserve 5 minutes for rebuttal. The question before this court is whether the denial of a statute of repose defense in general, and GARA in particular, is immediately appealable. Legislatures enact statutes of repose to protect defendants, not just from adverse judgments, but from the costs of litigation. Avoiding the burden of trial is the legislature's policy justification for a statute of repose. For that reason, this court has called statutes of repose a form of immunity. And just like other forms of immunity are immediately appealable, repose denials should also be immediately appealable. In Lee versus Baxter, the Court of Appeals said the opposite, that the denial of a repose defense does not affect a substantial right, but this court should reject that decision. As I said, repose is a form of statutory immunity, just as this court held in Black versus Littlejohn. In Black, this court was analyzing a malpractice statute of repose enacted by our General Assembly, and the court held that the statute of repose, quote, clearly had the effect of granting the defendant an immunity to actions for malpractice after the applicable period of time had elapsed. In the very next sentence, the court explained the reason that a legislature would enact a statute of repose is to reduce the costs of litigation. And as it turns out, GARA is identical. The congressional record shows that Congress enacted GARA to be a form of immunity for the general aviation industry. After Congress enacted GARA to protect that industry, just like our Congress enacted GARA to protect that industry, just like our General Assembly enacted the malpractice statute of repose to protect the medical industry, as this court noted in Black. In pages 718 to 720 of the record on appeal, Congress explained that the costs of defending against old claims were what had harmed the industry, and GARA was enacted to lessen the impact of those claims. For both GARA and our medical malpractice statute of repose, the injury that the legislature was seeking to remedy was the cost and burden of trial, and that is the same type of harm protected by any other type of immunity. Because the harm being protected against is the cost of trial and the burdens of trial, there's no way to recoup those costs once they're incurred. So the right to an immediate appeal is necessary to protect the right. Similar defenses, when they're rejected, already permit immediate appeals because the right can't truly be protected in any other way. We allow these appeals because they burden a party with a trial when the party has a right not to be tried. For example, besides immunity...
Counsel, could you go ahead and respond to the argument that that this is an attempt to appeal an original decision from 2 years ago as opposed to the actual appeal? It's a motion to reconsider, and why, in your view, that the ruling on the motion to reconsider is, in effect, a new ruling?
Yes, Your Honor. So the first argument that the plaintiffs are making is that we're appealing from an order denying a motion for reconsideration. But that's really not quite accurate. Although the court's order does in fact say that it's denying reconsideration, what the order does in fact is amend and modify the prior summary judgment order, changing the basis for the denial of summary judgment. And the trial court recognized that its prior court was erroneous. He wrote that right in the order. And so he gave a new reason to deny summary judgment in the second order based on GARA.
And
Now,
there's actually no such thing as a motion for reconsideration in our state court system, right? So, go ahead.
yes, Your Honor. As Your Honor noted when you sat on the Court of Appeals in Doe, 54B sort of implicitly recognizes that any interlocutory order can be revised at any time. So sometimes parties cite 54B as the authority for a motion to reconsider. In fact, that's what was filed. That's what was cited here. They actually cited your case, Doe, and 54B in the motion.
So if the court does in some way change its ruling, then it would be a modification of the earlier ruling under Rule 54, it seems to me. I mean, I can see a situation where the court would just say, I decline to reconsider, and perhaps that, we would just review that for abuse of discretion. But if the court does engage in examining its earlier decision based on the new arguments and makes a different ruling, it seems to me that that would be a new ruling just from the text of Rule 54. What am I missing about that?
I don't think you're missing anything, Your Honor. That's precisely our argument.
Well, can I ask you this question about that? If the trial court the trial court could have just denied the summary judgment motion without giving any reasons, right? Our law doesn't require that the trial court list findings of fact and conclusions of law and justify a ruling on summary judgment, right?
That's correct, Your Honor.
And so if in this case, if all that the trial court had done was on the first order, deny summary judgment, the motion to reconsider is filed, the trial court says, again, I deny summary judgment, would you still say that nevertheless the second order could be appealed?
No, because in that scenario, Your Honor, the second order is not modifying the first order, or if the judge sort of thinks that he is, he certainly hasn't informed the parties or said that he is. And so in this situation, after the first motion for summary judgment was denied, it was apparent that the plaintiff was going to go have one GARA misrepresentation theory going to trial. The trial court then realized that theory was wrong as a matter of law. He changed it. So they are now proceeding to trial under a different misrepresentation theory. So the whole course and trajectory of the case has been changed because of the order on the motion for reconsideration.
Right. But my concern here is why should whether or not there's a right to appeal a denial of a motion to reconsider turn on whether or not the trial court, which has the discretion to give reasons or not give reasons, gives reasons. That seems to me somewhat arbitrary.
Well, I think it was important in this case, Your Honor, because the trial court is trying to help the parties understand what the issues are to be tried. He's sort of taking one issue off of the table, saying, no, this is going to be the issue that's going to be tried. So I understand Your Honor's point that a bare order that just says denied, or an order, you could even imagine an order that simply says, I said what I said the first time, and I'm just not going to change my mind. But that just isn't what this order does. It actually amends the basis for denying summary judgment. So I don't think it's arbitrary. I think that, while we respectfully disagree with Judge Bridges' ruling, I appreciate what he was trying to do. He's trying to help the parties understand what the issue is going to be for trial so they can go prepare for trial.
But it seems like the lesson from this circumstance, if we agree with your position, would be anytime you miss your deadline for appealing a denial of summary judgment, just file a motion for reconsideration, and then you can appeal when that's ruled on. Well,
so in the ordinary course, that's not going to happen for a few reasons. First, this was a Rule 2.1 case, so Judge Bridges ruled on the original order, and then so he had the authority to sort of overrule his own order. That's of course not typically true. If this had been not a Rule 2.1 case, a second judge could not have come in and said, well, Judge Bridges was wrong the first time. We don't normally allow one Superior Court judge to overrule another. So I take your point, Your Honor, but I don't actually think that is very likely to happen very much in practice. And of course, many judges, often a motion to reconsideration will simply fail. The judge will just stand by their original decision. I mean, if that had happened and he had just written an order saying, I'm not changing my mind, we'd be in a much more difficult spot. But that's just not.
Oh, and that's what I want to ask about, because it seems to me that to some extent, what the argument we're having right now is kind of almost like a side issue, an academic issue. Because there's a deeper principle here, which is we don't have that many interlocutory appeal cases here at the Supreme Court, but we do have one that's cited quite frequently, which is Sharp v. Worland. In fact, we just cited it in our last drop of opinions. And one of the things that Sharp says is that when you take an interlocutory appeal and say, this order, challenged order, affects a substantial right, the courts don't look at the merits of the ruling and whether or not you're likely to win to determine if it affects a substantial right. Instead, you just look at, is in fact the argument you're making, what you're saying, does that satisfy the substantial rights test? But we had that qualifier, which you said, unless the argument is frivolous or insubstantial. And so your friend does not make this argument because I think your friend, reading the brief, I'm not even sure understands the legal questions that we're faced with today. But it seems to me the strongest argument against your position would be to say that is essentially a motion for reconsideration. We're going to look at the trial court's decision here under the abuse of discretion standard, which means we could only reverse if it was so manifestly arbitrary that it was not the result of a reasoned decision. And reading the trial court's order, it does not satisfy that standard. And therefore, this is an insubstantial attempt to appeal. And that would be the reason why we would acknowledge there's no appellate jurisdiction. So respond to that argument, which seems to me to be the strongest one against your position.
So I think that argument is sort of intertwining the merits. So normally we think of a substantial right. We say, well, we don't really care whether you're going to win on the merits, but what's the right? And if we don't protect it with intermediate appeal, is essentially going to be, that right going to be seriously injured in some way. It doesn't have to be completely denied, of course, but it has to be injured in some way. And that's our position here, that if we couldn't appeal here, could we have appealed from the first summary judgment order? Of course. It turns out it was probably better to have waited so that you could have some clarity on what the trial court actually thought. So I think it works out just fine.
But let me push back on that because, I'll give you the easy Sharp v. Worland case, which is somebody gets sued, they file a motion to dismiss, it gets denied, and then they immediately appeal and say, I have sovereign immunity. This is a random person. So anyone can look at that and say, no, you don't, you're not the state. And so I think under the Sharp v. Worland test, we would say, yes, we can say you can't take an interlocutory appeal here. Why? Because the argument you're making is frivolous or insubstantial. It meets that criteria where you didn't even get to the bar of we're looking at the substantial rights argument.
Sure.
And so I think the best argument here is to say, so I understand you're saying we're intertwining with the merits, but Sharp says you can do that to sort of this like minimum baseline test. And it seems to me the strongest argument here is because you're at abuse of discretion on a motion to reconsider, that's the problem, is that is such a high bar that if we conclude it was in fact a motion for reconsideration, that you can't immediately appeal because you're not going to meet that test. So what's your response to that?
So abuse of discretion is always, it's a very forgiving standard, but errors of law are per se abuses of discretion. We didn't reiterate all of our merits points in our opening brief into this court, but our cert petition lays out our theory of the merits. They're very straightforward. I mean, the first is, well, you have to plead GARA, and you have to plead GARA's misrepresentation exception in your complaint. Anyone can pick up this complaint and know that just didn't happen. Judge Bridges essentially refused to enforce the pleading requirement. We think that he got the sort of the proof requirement wrong as a matter of law as well. So we have purely legal arguments, and so we think that this is not a. To me, I have not seen. I understand that Sharp says we can peek at the merits. I'm not sure I've actually ever seen a case really applying that. This case, I certainly don't think reaches that bar, but we have strong legal arguments. We have good arguments that will meet an abuse of discretion standard. And I think that what we did here was appropriate. Whether we could have appealed from the prior order or not, I think the record bears out that this was probably turned out to be a fruitful way of going about doing it anyways. So my friend on the other side has also argued that we're actually trying to appeal from the first order. Just want to be clear, we didn't file a notice of appeal from the first order. We're not attacking the first order. It wouldn't make any sense to try to attack the first order because it's not the law of the case anymore. Judge Bridges had changed his mind about what misrepresentation theory the plaintiffs can pursue. I did want to mention just a few other examples of substantial rights that have been recognized by our court besides immunities that involve, essentially what the doctrines are designed to protect against is the burden of trial. Because I think it's helpful to think about this case both in the immunity context and in the non-immunity context to understand that they're all supposed to work the same. Whether this court essentially adheres to its ruling in black and saying it's effectively immunity or not really doesn't matter, because what we have to ask is what the legislature doing with this doctrine trying to protect against the burden of trial. So I'll give you one example, which would be personal jurisdiction defenses. Personal jurisdiction protects against being hauled into court, a court that has no right to adjudicate those particular claims against that particular defendant. You have a right against that, and once you're tried in that court, there's really no way to restore those defense costs. So we recognize that the denial of a personal jurisdiction motion affects substantial right. Similarly, we have contractual venue selection clauses and arbitration clauses. The parties in those cases have contracted not to be sued in a particular court or not to be sued in any court at all for arbitration. And so once those rights are violated, there's just no way to undo that kind of harm. And now the same logic, I think, also applies to res judicata defenses. Res judicata protects against the burden of defending against the same claim twice. If you have to defend against the same claim twice, it doesn't matter whether you win the second time on the merits or not. The doctrine is designed to protect you of the burden of defending on the second claim altogether. That's why res judicata is also a basis for a substantial right appeal. As each of these examples show, when there's a recognized right not to have the burden of trial, then the denial of that right always affects the substantial right, whether you call it an immunity or not. And we think the same thing is true of proposed defenses. Now, my friend on the other side has also argued that because the trial court determined that there was a dispute of fact about GAR's applicability, that there couldn't be a substantial right appeal. But that's not how the substantial right doctrine has ever worked in this state. If a right is a substantial one, then its rejection at summary judgment is immediately appealable, even if the trial court is just deciding that there's a dispute of fact to be resolved at trial. This court said that repeatedly. I think this court maybe said it most clearly in an opinion by Justice Earls in 2022, Bartley versus City of High Point. There, the trial court had denied a defendant's motion for summary judgment on public official immunity grounds, concluding that there were disputes of fact about the immunity that have to be resolved at trial. The issue in particular in that case was about whether a police officer had engaged in excessive force. And the answer to that question, of course, is always going to be fact intensive. But this court expressly held that the defendant could still appeal despite the fact intensive nature of the substantial right. The applicability of the substantial right in that case, writing that the denial of summary judgment on the ground of public official immunity is immediately appealable because it affects a substantial right. Now, relatedly, I think also doesn't matter that we're talking about exceptions to GARA. Litigation over exceptions in a legal doctrine don't impact the substantial right analysis. Virtually all immunities have exceptions, and the litigation is pretty much always focused on those exceptions. For example, this court deals with lots of exceptions to sovereign immunity and governmental immunity, waiving immunity through contracting, quorum claims, the purchase of liability insurance for local government entities.
So sorry to interrupt you.
Go ahead, Your Honor.
Just wondering, do we have to get to the big question of whether a statute of repose in all cases constitutes or provides a substantial right? Or could we just say that GARA very clearly says no civil action may be brought, and that's enough for a substantial right in this case?
I think that this court could absolutely do that. That's sort of the strategy that the Pennsylvania Supreme Court took in Pridgeon. They said, we're not really going to, they really just focused on GARA. They recognized that maybe the logic of their reasoning could apply to maybe some other reposed offenses, maybe all other reposed offenses, but they decided they're just going to, I read the opinion as saying, we're going to do this on a case-by-case basis. And since this was sort of the first time this issue has come to this court, I think it would be fine for this court to take on a case-by-case basis. I don't see that there's anything wrong with that.
Thank you.
One thing about that, though, is that language from GARA in the footnote in McKinney, where this court sort of took some of the law of the statute of repose and said, what exactly is a statute of repose, distinguishing it from a statute of limitations. We said that all statutes of repose in North Carolina are the exact same thing that GARA says it is, right?
I'm not going to dispute that the logic of this court's case law suggests that it is likely that all repose denials are immediately appealable. But if the court is more comfortable taking a case-by-case approach because the record is so strong for GARA, then I can understand that approach as well.
But it's true that there are exceptions to this. In GARA's statute of repose, there are exceptions. Correct?
Yes, Your Honor.
And so if those exceptions apply, then the repose would not attach, right?
Yes, Your Honor. I mean, that's true.
And the dispute, it seems to me that the disputed issue here goes to whether or not that exception exists as a factual matter in this case. And if we, it seems to me if your argument is they don't get the benefit of GARA because they didn't plead it, that's one kind of legal question. But if the question is, does GARA apply because one of the exceptions applies, that does require some kind of factual determination. And so how can we decide that as a matter of law if we don't know the facts about whether the exception to GARA should apply here?
Well, we don't think that it, so they have essentially two theories on, we have two theories on the merits. So the first is, well, you have to plead the misrepresentation exception. It's written right into GARA.
And was that argument part of the summary judgment motion under the first order? Because did the court change its ruling on that theory?
The court essentially ignored the argument in both of the
Which is the same as my example earlier, where there's a summary judgment order that doesn't give any reasons.
I mean, I think it's not that unusual, actually, to see summary judgment orders that are, sort of, I call them partly reasoned, where they address some of the claims, and sometimes you may have boilerplate language at the end saying, and we also disagree with all your other arguments, or sometimes they don't have that sort of cleanup language, but it's sort of apparent by the decretal language what's being resolved. So I don't really think that that is a problem in this case, but I just want to be clear that our arguments here really don't depend on the facts. We're sort of accepting that.
And just let me clarify, because I want to make sure I'm not getting confused here. So for example, I'll take public official immunity, but you can pick any immunity. There are a ton of exceptions to public official immunity, many of which involve fact questions. And that's what I was going to say, is in Bartley demonstrates that even when there are those fact questions, the courts have appellate jurisdiction because the argument that I have public official immunity is enough to satisfy the substantial rights test. And then the court, on the merits in reviewing with jurisdiction, the appeal may say, we can't get to it at this stage, you need to go to trial or whatever. But it has nothing to do with the jurisdiction of the appellate courts. Is that
That's
right?
exactly right. So Bartley was dealing with, I believe, the malice exception to public official immunity. And that's all we wanted at the Court of Appeals.
And so it would be the same thing here with GARA, is what your argument is. There are exceptions to GARA, but GARA is creating this sort of immunity from suit that can be immediately appealable. Therefore, the courts have appellate jurisdiction to examine the merits of the argument. That's your position.
That's absolutely right, Your Honor. We believe that the court could decide was able to decide on the misrepresentation exception as a matter of law at summary judgment based on the record before it, because it raised really purely legal questions. There were no disputed facts for the way that we had decided to present the defense. If there are no other questions, Your Honors, I'll save the rest of my time for rebuttal.
Thank you, counsel. We'll hear from the Appellee.
Good morning, Mr. Chief Justice and Your Honors. My name is Arthur Walk, and I represent the plaintiffs in this case, the Appellees. Initially, I want to thank you for the opportunity to be here. I am a Pennsylvania lawyer, and I understand that I'm here as a guest, and I'll conduct myself accordingly. Counsel has argued that we have failed to properly plead the exception to GARA, which is very simply that if there has been a knowing misrepresentation or withholding or concealing from the Federal Aviation Administration required information that is material and relevant to the performance, maintenance, or operation of an aircraft or its components, and where it is shown that the misrepresentation was causally related to the harm. That is an in-depth factual analysis that is to be determined by a jury. The carelessness or recklessness or failure to warn has been determined by the court below to be a jury question on 2 occasions.
Well, I hate to interrupt you, but that's the merits of the Gara argument.
No,
We're
sir,
here-
I'm arguing the pleadings argument that was made a moment before, that we had failed to properly plead. That is an argument that I might add was not made in their motion for reconsideration, was not made before the Court of Appeals, was made for the first time here on appeal.
Right, but what I'm saying is whether your client's going to win on the Gara argument or your friend's client is going to win on the Gara argument doesn't matter to the question that we're reviewing today. Our only question is, did the Court of Appeals have appellate jurisdiction to examine that question? The Court of Appeals concluded it didn't even have jurisdiction because you couldn't immediately appeal. So that's the only issue that we're going to take up today.
And I'm pleased to address that issue, and that is that the Court of Appeals did not have jurisdiction for a number of different reasons. The first is that there was no attempt to appeal the decision on summary judgment for 2 years, meaning there was no attempt to get a motion for reconsideration for 2 years by the defense.
So why would that have anything to do with the appellate court's jurisdiction?
Well, it would show that the appellant had failed to assert its rights, and it's now arguing before this court.
But you can't waive jurisdiction. So if you fail to timely raise something, it has no impact on the court's power to adjudicate a matter.
I understand.
Subject matter
That's exactly why
non-waivable.
That's exactly why the Court of Appeals dismissed the appeal. As soon as they had an opportunity to take a look at it, they dismissed it.
Well, no, they dismissed it because they have a 25-year-old decision in which they reasoned that a statute of repose does not affect is not a vested right, and therefore it's not like an immunity, and therefore like a statute of limitations ruling, it's not immediately appealable. The problem is we have Black v. Littlejohn, which says that's not the case, our precedent, and then we have more recent precedent like McKinney that clarifies that statute of repose is quite different from a statute of limitations, and it is a vested right.
That's right. And Land versus Whiteley, that was just decided by this court on October the 17th, seems to rule that an immunity defense or an immunity not requirement for appeal is different from an immunity from liability. GARA is an immunity from liability, and therefore there is no right for an immediate appeal. So this court has no jurisdiction on that basis.
And that is the argument. That's your best argument. So
well, it's the case that was just decided on October the 17th, so it apparently is the law of North Carolina as recently expressed by the court.
Right, but what I'm saying is that I agree with you, Land v. Whitley is our precedent now. What I'm saying is your friend argues that under Land v. Whitley, this is an immunity from suit. It's not a defense to liability. It's a guarantee that you won't even be dragged into court to have to litigate after that period runs under GARA. You know you'll never have to come to court, and your position, as I understand it, is no, it's just a defense. At the end of the trial or at some point you say you have no liability because GARA says you can't be liable, and we need to figure out which of those two GARA is. It seems to me is the key question here.
Well, it is, and I certainly would tell you that most courts who have addressed the issue have addressed it in favor of our position. There are several courts.
What about your home state of Pennsylvania?
Well, it's a very interesting point you raise, and it's interesting what happened after that. What the court said was, since there was no dispute basically as to the fact that the parts that were replaced within the 18-year period, in other words, the replacement parts exception, were not furnished by the defendant, the court held that there could be no liability on the part of the defendant for those replacement parts. However, what he did was, this is the Chief Justice now, sent the case back for factual determination of whether or not the second exception, the one we're here about, applied. That was determined by the trial court, was appealed to our intermediate appellate court, who then said there was no immediate right of appeal, appeal dismissed. So if we follow that case holds exactly what we are asking this court to do. On the issue of the fact-intensive misrepresentation, knowingly withholding information, that there is no right of immediate appeal, even if you consider our Supreme Court's decision in the case you referenced. So the most important point here for this court's jurisdiction, it seems to me, is that there was no petition for certiorari filed for 8 months, and they failed to file a petition for certiorari before the Court of Appeals. So we have an exception, a petition for reconsideration where there was no change in the court's conclusion, no change at all. What he said was, in the first decision on the motion for summary judgment, was that the jury may have to decide these factual questions. On the motion for reconsideration, he said the jury will have to decide these factual questions. Well, that's no difference. The jury always has to decide factual questions. But as a matter of
Isn't that argument, again, getting back to my earlier point, I mean, you're making an argument that's perfectly reasonable, but isn't that one that's about the merits of whether or not the trial court's order on the reconsideration should be affirmed or not, which is something the Court of Appeals never reached because they said they didn't have jurisdiction. In other words, the jurisdictional question, your friend in making the appeal said this affects a substantial right, it's a statute of repose, and if we determine the statutes of repose are immediately appealable, then the court had jurisdiction. It needs to get to the merits of your argument and listen to everything you're saying right now and say you're going to win. But the court never did that, the Court of Appeals.
Well, because the Court of Appeals didn't have jurisdiction to hear the appeal anyway, because they've held uniformly that there is no appeal from a denial of a motion for reconsideration.
Well, they held it once 25 years ago, and then, of course, they're stuck with it until we step in and say
well, where they change it, right? I mean, and they chose not to change it.
Well, they can't change it, Art. They're not allowed to overturn their own precedent. And that's why I think we took the case, because we had never examined this principle. And what I'm asking you is, if we determine that these are immediately appealable, all that's going to mean is that the case goes back to the Court of Appeals to listen to the very argument you're making now. So it seems to me that you should be focusing on why it is that the statute of repose doesn't affect a substantial right, because Lee versus Baxter, the Court of Appeals case, does not appear to have a very strong foundation when you look at our case law. I mean, it said things about statutes of repose that are not correct. For example, it said it doesn't implicate a vested right. We now know from McKinney that's not true, and there's various other examples.
Well, but we also know that the Gara statute does not say that there is no requirement that a defendant stand trial.
Doesn't it say no civil action may be brought?
And then, well, yes, that's the blanket rule. No civil action may be brought, and then it has exceptions.
Well, I realize that it has exceptions, but you argued earlier, I think, and you can correct me if I'm wrong, that it's really a defense against liability and not against suit. And I'm just wondering how much clearer Congress could have made it that what's intended here is is protection against a lawsuit itself. No civil action may be brought. If they had just intended a defense against liability, they certainly could have worded it differently.
Well, what they did in the exception, they stated specifically that the plaintiff must plead and prove the exceptions.
No,
so if we have to plead and prove, how can you not have a lawsuit if you're required to plead and prove? And so that wouldn't make any sense to say that, well, you can't file a lawsuit, or if you can file a lawsuit, it's subject to an immediate appeal if you must plead and prove. If you have to plead and prove, that's a trial. That's not something that you're doing even by way of summary judgment. So is the language a model of clarity? Most statutes aren't, sadly. But the bottom line is the exception that we are dealing with is one where Congress has specifically provided a mechanism by which we can reach that exception from their immunity. And that's a deeply intensive factual development.
But I guess what I don't understand about that is that, for example, there are so many examples of this in our immunity laws, but just to take another one, it would be governmental immunity. So for our local governments here, that in order to pierce that governmental immunity, you have to plead and then prove one of the exceptions. One alternative would be that the local government purchased liability insurance. And again, that is a fact question. I mean, you have to prove that, and you'd also have to plead it. If you don't, then you'll be barred by governmental immunity. But that does not change the jurisdictional analysis, that if there's an appeal saying the trial court ruled against me, the local government, and said, I don't have immunity, that it's immediately appealable. It gives the appellate court's jurisdiction. So why is the language in GARA any different? Its opening statement indicates, the broad statement, that it is an immunity from suit.
Yes, it does say that, except that the exceptions take that away. Because in order to meet the pleading and proof requirement, you have to have a lawsuit. So it would make no sense. You can't plead and prove something if you can't file a lawsuit. And they intended to make that exception so that there is no immunity from going to trial, for example, or having a trial or having a lawsuit.
I don't understand that argument, because immunity to get to us is always raised in the context of a lawsuit. It seems that you almost seem to be saying, well, if GARA applied, we couldn't have filed our lawsuit.
Well, no, I thought that's what you were arguing to me, and I'm saying,
No.
no, that isn't what Congress
No.
intended at all.
No, what I was saying is that GARA is intended to protect covered entities from suit, and therefore there would be a substantial right involved.
And my argument is that if Congress wanted to have a substantial right determined preliminarily, they certainly could have said it. But I will say something that, to me, I've had difficulty appreciating in the context of my friend's argument, and that is this. Everyone has a right to file a motion for summary judgment. And that is the determination of whether or not the facts pled and proved are sufficient. And what is the reason then to allow in this particular context an appeal that takes years and years and years to be decided, when Congress was very specific as to how this should be dealt with by the courts? Pleading and proving, that's a trial. If the parts are replaced, that's an exception.
Are you entitled to a trial if you don't plead with specificity?
Well, we did plead with
No,
specificity.
but I'm not asking whether you did, but I'm just asking the theoretical question.
No, what you do is you file, according to the North Carolina law, what you do is ask for a more specific pleading, or you ask for an amendment. That would be under Sutton versus Duke, which is a North Carolina case. I mean, the reality is that we did plead it, and what you're saying, and I agree with, if you don't plead and prove in a notice pleading requirement, as North Carolina is, if you don't plead and prove the exceptions, then someone could file a motion for a more definite statement. They could file a motion for judgment on the pleadings, and then the plaintiff would presumably ask for an opportunity to amend, which in North Carolina, under North Carolina law, you can do even after trial.
I think the point is, if you haven't pled with the specificity required by the GARA exception, then the bar against a civil action remains applicable. And so the protection from suit remains applicable.
Not, for example, if there were replacement parts. Not, for example, if someone was killed on the ground. Not, for example, if it had to do with a medical flight. So, no, I don't agree with that. That's not what it says. If Congress intended to make it a substantial right, these fellows are pretty smart, the ones who are considering this. They certainly would have put it in the statute. The reason the exception is there is so there can be a trial on the issue of whether or not there was a knowing misrepresentation, or an issue of whether or not there was a replacement part.
Right, but we're not dealing with the merits of this case. So what we're trying to get you to do is sort of step back from the specifics of this case and just deal with the theoretical question. Under GARA, or GARA says no suit may be brought. There are exceptions. To qualify for the exceptions, one thing you have to do is plead them with specificity. So the question is, if you have a lawsuit that does not meet that pleading standard, wouldn't you agree that the protection from suit in subsection A of GARA would apply?
Yes.
Okay. So why wouldn't a party that is arguing that GARA protects it from suit be able to appeal and argue, for example, that the exception doesn't apply because the pleadings in this case don't satisfy the specificity requirement?
Well, I think for a number of reasons. The first is that the appeal, at that point, the case would be thrown out, so there would be nothing left to decide. So there's always an appeal when a case is completely out of court. So that would be the situation I think you're describing. The second part of it is that once a lower court decides that the plaintiff has established a sufficient factual basis for meeting one of the exceptions, then there is no substantial right, in my view, for an appeal then, because the matter is not concluded. Otherwise, you would have the right to appeal every interim decision by a lower court on a summary judgment issue. And once he decides that, you have to go back to the standard, either abuse of discretion or whether or not there's a substantial right involved. I think what happens is we kind of are going in circles. The bottom line is that GARA provided an opportunity, understanding that there can be a demonstration of knowing misrepresentation, for there to be a full lawsuit and trial on the subject. And if there's going to be appellate jurisdiction, it should be after that decision has been made by a jury, or all of the issues decided that need to be decided by a jury.
You would agree, wouldn't you, that Congress did envision that if there was no genuine issue of material fact, the court would enter summary judgment? There would not be a trial if there were no fact issues for the jury.
Correct.
So in a circumstance like that, where you're appealing at that stage, the argument that the party asserting the GARA immunity would be making is I should have wanted summary judgment. There's no genuine issue of material fact. It doesn't need to go to a jury. My point being, at every step of this, it's just the ordinary litigation process playing out. I understand you're saying there are fact questions, but of course, the party on the other side is going to say that, but there's no genuine issue of material fact, or they're going to say at the pleading stage, there's not a sufficient allegation in this complaint. Well, then an exception to GARA and so on. And in any of those circumstances, if that's that litigant's argument and they appeal, then the question just becomes, well, is this a immunity from suit? And if so, it's immediately appealable, the denial of that motion.
And all I'm saying is that if you make that argument, that means that every single case where a trial judge has made a decision that facts would allow a trial on the subject is immediately appealable.
Well, here in North Carolina, that is how it works with immunities. So, for example, if you made a sovereign immunity argument at 12b-6 and you lost, and because there was a fact question, you could appeal again at summary judgment and say, I think there was no genuine issue of material fact, that it makes it something that's immediately appealable.
And that has been the truth with respect to immunities, and we've listed them in our brief, except for GARA, with one or two notable exceptions. But most cases that have held it, Sekeli, which is a Third Circuit case, Neff, which is a Florida case, Robinson, which is a Third Circuit case. There have been loads of cases that have decided in this way, where there is no, where appeals have been denied on the basis of these GARA exceptions.
But weren't those in federal court, though, those cases?
Well, some are in federal court and some are in state court.
Because it's the question of whether here in North Carolina state courts we will allow a particular issue to be immediately appealed is not something Congress decides for us. It's not a substantive issue, it's a procedural one. So it's really about what our state law says about appealability.
Right, and the question is, since as I read the case law, I'm not sure I agree that there's the cases that hold an immediate appeal are usually on those immunities that are blanket immunities with where there are very few exceptions allowed, and those exceptions are determined not to, will allow immediate appeal. But in terms of GARA, I don't understand this. If the statute itself provides essentially that you go to trial and does not provide that you don't go to trial, I'm not understanding why with GARA's exceptions the way they are, somehow that is the same as an allowable appeal on an immunity as blanket as the immunities are. And I thought this court just held exactly what my argument has been. And that is, you have to take a careful look at the statute, and you have to see whether it's immunity from liability or immunity from suit. And I agree with Your Honor that Congress says that there shall be no suit, but then took it away with the exceptions.
Yeah, I don't know that I find that convincing because, and immunities have been mentioned throughout, and public official immunity was raised earlier. I mean, public official immunity only applies if you're a public official and not an employee. It doesn't apply if your actions were malicious or corrupt.
Right.
So those are all exceptions, but because it's an immunity from suit, if you raise it and you lose on it, you have a right under our case law to immediate appeal, even though it might be determined by the appellate court, well, no, the pleadings here establish that there's an exception. You might lose on appeal, but because the substantial right, or the right that's at issue, is a right to be free from the burden of litigation, you still get an immediate appeal. And I'm struggling to see why this is any different given this pretty clear statutory language in subsection A that says no civil action may be brought. The fact that there are exceptions, that just means that the defendants might lose on their appeal when the merits are reached. But it's hard for me to see how that means they don't have the right to have an appellate court determine whether the immunity applies.
Well, in this case, I think there was waiver wholly aside from whether or not an immediate appeal would be allowable. I don't think it furthers the interest of Congress to have for plaintiffs, for example, where Congress mentioned they wanted to establish a balance between trying to provide some immunity for manufacturers, while at the same time not foreclosing legitimate lawsuits, at least on the exceptions that were provided for in the statute. And I know the distinction that you're making. The filing of the lawsuit may be one thing, but the entitlement to an immediate appeal is wholly another. And I think that it's an interesting question, but in this case, there was a complete waiver. And I believe that the Court of Appeals was correct in concluding that, well, not only was the Court of Appeals correct, but also the lower court said repeatedly that this is an interlocutory order. There's no entitlement to appeal. The Court of Appeals obviously felt the same way and dismissed it entirely. No petition for certiorari to either the Court of Appeals, so they went around them to get to you. And now we're in a place where it is my belief, I shouldn't say my belief, but I believe it's the law, that we should not be, which is an immediate appeal of a fact-intensive case like an airplane crash versus something that is can be cured with an affidavit for immunity based on governmental immunity, for example. That I am, for example, I am an officer of a township or county, and therefore I am immune because there's been no allegation, for example, of some horrific conduct on my part. And so I think what happens is that would mean that prematurely, without even a trial where all the evidence comes in, there would be an appeal all the way up to this court, which means, as in this case, an 8-year delay in justice for the plaintiffs just by machinations. Even there may be no merits. I don't think that serves the interest of justice at all for anybody. It simply is delayed. And but I understand your analysis and your thinking about it, that if immunities are immediately appealable based on the decision that there is or is not, then there's appellate jurisdiction. I get it. But it would make, to me, it's an interlocutory order that is not appealable. So one has to reconcile whether we're dealing with the interlocutory order issue or we're dealing with an immunity issue, and I believe, as I read the case, Land versus Whitley says you have to look at it more carefully than just granting an appeal.
Counsel, in your brief that you filed opposing the North Carolina Home Builders Association, you made some serious allegations against attorneys in this state. Do you stand by that brief?
The only thing I will tell you, was it the Home Builders brief or the Gamma brief? Because the Gamma brief I stand by completely. The Home Builders brief, I simply pointed out to the court facts. The facts are...
So you did more than that. You said, nor did appellate counsel reveal that his third brief for appellant was his doing and his doing only. Now, is that a fact?
I can't answer that at the moment. I don't recall.
You filed something with our court. How can you not answer that?
Because at the moment, I'd like to point something out to you that supports my position. And that is, in the reply brief, appellant's counsel gave an impermissible reply argument for both amici. Now, if you're going to make an argument for both amici that is not permitted by this court, then how in the world can you say that you weren't involved in the preparation of the brief?
Did you make allegations in both of your responses personally against counsel?
No, sir.
Are you saying that nor did appellant counsel reveal that this third brief for appellant was his doing and his doing only? How is that not a personal allegation?
Well, I don't view it as that.
What do you view it as?
I view it as a fact that there was no disclosure.
And you have information that would support that fact.
I gave it to you. I actually gave you the information. In my responsive brief to the amici, I pointed out that the appellant counsel who represents Lycoming, a division of Textron, stated that that his brief was independent of the amici brief. Well, that's not so. Textron is Gamma. Gamma was the amici. Textron's lawyers were involved, as was he. This is not something that is not well known. I simply pointed it out to you and showed you factually that I'm right.
So your view, when you said that the brief we're talking about did not list the required footnote, even though there is a footnote in that brief, you are maintaining that counsel who filed that brief lied?
No, sir. I didn't say that. I would never say that.
Is
I don't
the footnote
intend to say
there
that.
or not there?
I'm sorry?
Is the footnote there or not there?
The footnote does not adequately describe, in my view, the role of Textron in the preparation of the responses in this case. And I believe that it should have been disclosed. That one of the amici is in fact tantamount to being the defendant. This is in fact the second brief being filed for the defendant in the case. And I think that has been confirmed by the response, by the reply brief, and I'll give you the language if you want.
Counsel, your time's expired.
Thank you very much, Your Honor.
Mr. Chief Justice, on the personal allegations against me and our amici, I just want to be clear that I had no role in preparing any of the amicus briefs in this case or in any other case that I have ever been a part of in this state. I would note that Gamma is a trade association. Textron is one of its members. Lots of other large corporations are among the members in this trade association, including companies like Boeing. To the merits of the issue actually before the court, I want to emphasize that the fact-intensive nature of an order never affects the substantial rights analysis. Consider issues about attorney-client privilege, minimum contacts analysis for personal jurisdiction, preliminary injunction disputes and non-competes, and trade secrets cases, all very fact-intensive they all always still affect a substantial right and are appealable. Pridgeon and some of the federal cases look at the fact-intensive nature because that is required by the federal collateral order doctrine. Pridgeon, although a Pennsylvania case, has adopted the federal collateral order doctrine. But as Justice Dietz noted, our substantial right doctrine never cares about the fact-intensive nature of the order being appealed from. I think Bartley is a perfect example of that. I think my friend from Pennsylvania simply doesn't appear to be familiar with that feature of our case law, since it is very different than the collateral order doctrine. The substantial right doctrine is really somewhat unique to North Carolina in my experience. And my friend on the other side complains that we didn't file a certiorari petition with the Court of Appeals, and of course that's true, but the Court of Appeals, as members of this court know who have sat on that court, generally don't allow you to file a cert petition in an appeal like this one until the record's been docketed, and we never had an opportunity to even file our opening merits brief in this case, which is when we were going to file our certiorari petition, which is rather normal, I think. And the Court of Appeals dismissed the case quite early. Justice Allen, to your point earlier, I think that the Kennedy case vindicates your point that the plain text of GARA shows that the statute proposed is designed to protect against the burden of trial. I'd say that the congressional record also bears out that point. And you know, if there are no other questions, what we'd ask is that the court reverse the dismissal order of the Court of Appeals and remand this case back for briefing on the merits back at the Court of Appeals. So if there are no other questions, we thank you for your time.
Thank you, Counsel. Ms. Clerk.
All rise. Oh yes, oh yes, oh yes. The Supreme Court of North Carolina will be in recess for 15 minutes. God save the state.